Hello, it is a great pleasure to open the second webinar that is organized and that is a webinar in the series of 4 webinars on punishment, detention, crisis, academic judicial dialogues that is organized by the criminal law group of the court in cooperation with the Beyond Detention interest group from Liverpool John Moores University, with Bologna University, and with cooperation of Zagreb Faculty of Law. Today we are talking about border crossing and the right to liberty. We have exactly 1 hour and we have 3 speakers and a short introduction, and I will be very strict with timing because we cannot exceed the time. According to my information, we have 80 lawyers who applied from the court to listen to this webinar and more than 200 participants outside of the court. We are very happy about that. And I will immediately give the floor to Tristino Marinello, with whom, together with Paolo Loba from the court, we are organizing this series. So thank you very much, Tristino, and if you can take the floor is yours.
Good afternoon, everyone. I'm delighted to open this webinar and to see already so many participants today. Personally, and on behalf of the organizers, Judge Turkovic and Paolo Loba, I would like to thank our speakers today, Judge Meets and Professor Costello, as well as our discussant, Dr. Maria Giulia Giuffre, who have kindly accepted our invitation. For their support to the organization of the event, I also wish to express our gratitude to the Staff Training Office and the IT Department of the Court Registry, and also Liverpool John Moores University, the Bologna University, and the University of Zagreb. Before leaving the floor to Judge Turkovic and our panelists today, please let me spend a few words on the theme, purpose, and structure of this webinar series, and in particular on today's event. These webinars explore the human rights implication of the deprivation of liberty related to criminal proceedings, but also the human rights implication of those forms of detention existing outside the framework of conventional criminal justice process, and therefore escaping well-established guarantees against state's abuse in the exercise of its powers. In the March kickoff event, we addressed central legal issues arising from life imprisonment in relation to the European Convention on Human Rights. Speakers brilliantly discussed how life imprisonment without parole affects human rights and to what extent a whole life sentence may be compatible with Article 3 of the Convention. For those ones who missed the event, the video of the recorded event is available on the website on Liverpool John Moores University. Today we move on to explore a different area in which the limitation of personal liberty has overstepped the usual boundaries of criminal proceedings: immigration detention. Irregular migrants and asylum seekers, such as those subject to border procedures or to Dublin transfers, are frequently subject to confinement. Administrative detention is widely used for the management of the flow of irregular migrants and removing those with no right to remain. This raises human rights concerns in relation to the conditions, governance, and experience of confinement. Today, our guest will examine central legal issues that arise from border confinement of foreigners, such as the conditions under which confinement in transit zones and reception centre amount to deprivation of liberty, as well as the lawfulness requirement and procedural safeguards under Article 5 of the Convention as developed by the Court in relation to the detention of migrants and asylum seekers. Finally, a very few words on the aim and structure of these webinars before leaving the floor to Judge Turkovic again. This series brings together scholars, judges, and practitioners in order to facilitate the exchange of views on the tensions, as I said, between deprivation of liberty and human rights standards. The general objectives of the training series is to foster the dialogue between the academia and the court. Two words that, as Paolo said last time, have been at times criticized for not paying sufficient attention to each other, the academia in particular often depict as an ivory tower too distant from the actors that are called to implement legal theories. For this reason, every webinar includes a speaker from the court and two leading scholars in the field of human rights, one as a speaker and one as a discussant. In this way, even though the training events, the webinars are training events for the court staff, they are open to general public, including scholars, students, and human rights practitioners, who may ask questions or make comments through the live chat at the end of the presentation. So, before I conclude, our next webinar will be on Thursday, 20 of May, and it will be on detention during pandemic. Then the final event will be on Thursday, 24th of June, and will be on police power and national emergency. All the events are going to start at 4 p.m. You will find further information on the training workflow for registry staff or for the general public on Eventbrite page of Leopold John Moores University. Thank you for your attention, and I can now give the floor back to Judge Turkovic, who will chair the panel today.
Thank you very much. So we will start with today's presentations, and the first speaker is Catherine Costello. Catherine Costello is an associate professor of international human rights and refugee law at the University of Oxford and the co-director of the Center for Fundamental Rights of the Hertie School in Berlin. She has published widely on many aspects of EU and human rights law, including refugee law and immigration. She is currently the principal investigator of a 5-year research project exploring refugee mobility, recognition, and rights. She has also done studies for UNHCR, the Council of Europe, and the European Parliament. And since I have seen the presentation, I know and I can say that an exciting and interesting presentation is in front of us. Please take the floor.
Thank you so much, Judge Turkovic, and to Trestino for the invitation. It's a great honor to address this webinar, and I have to say I feel very privileged, but also I think these are wonderful opportunities to establish such direct conversations between scholars and judges. So I have a PowerPoint presentation, and I'm going to share it now, and I'm mindful that I have 15 minutes. So what I intend to do in this talk is 4 things. I want to look at how the court has interpreted Article 5(1)(f), the particular ground in Article 5 that allows for detention for immigration-related reasons. But I want to put it in context, and in fact, one of the main arguments I'm going to make is for a holistic interpretation of Article 5, rather than having immigration detention completely siloed off from the other principles that animate protections to the right to liberty in Article 5. Then I also want to very briefly speak to how the court's jurisprudence fits with other human rights standards, with the ICCPR, the Inter-American System, and the Refugee Convention. I'm going to do all of this in quite broad brush and just bringing out some ideas in other scholarship, some by other scholars and some by myself. And then turn to the current frictions between the Strasbourg Court and the Court of Justice in the European Union on the question of when detention actually exists, particularly in relation to transit zones, and then quickly draw some conclusions. So in a way, of course, the Article 5 case law is very rich and highly evolved, and I can't possibly do it justice in this period of time. But when I think about how to approach Article 5(1)(f), I think the court has set up in sort of foundational cases an approach that is quite entrenched, even though, of course, the case law has evolved over time and in some respects become more liberty protective. But when I explain this case law, usually I think of 2 foundational cases where some features of the case law still remain, even though, of course, there are nuances and subtleties in how the cases have developed. So concerning the issue of unauthorized entry in Sadi versus the UK, the court accepted the notion that asylum seekers were unauthorized until the state decided otherwise. So there was a quite broad power to detain in that context. Of course, one can question that, whether that was the right characterization of asylum seekers. But nonetheless, that power to detain was constrained. The detention had to be in a suitable place, not for too long, and so on. But once people fell into that category, they were amenable to detention, including for reasons of administrative convenience. The UK's argument in the case being that having all asylum seekers on site in a single place would make it an easier and swifter to process their claims. Time would show that the UK detained fast track never really worked like that anyway. And the dissent that I've quoted here on the slide is sort of a powerful reminder that some judges in the court didn't agree with this approach. In relation to detention for deportation, I suppose the foundational idea in Shahal is that, again, individuals facing deportation may be detained, but that doesn't need to be a demonstration that that's necessary in the particular case. So yes, there has to be a nexus between the likelihood of deportation and the practice of detention, but not a strict test of necessity in the individual case.
Professor Costello, sorry for interrupting you. We cannot actually see your PowerPoint presentation.
Oh, okay, sorry. Well, you've only missed one slide then, so let me go through this routine of the sharing again. Thank you for telling me. You missed one very rudimentary slide, which I'll show again. Hang on. Let's see if it works the second time. Thank you for telling me. Right, so can it be seen now?
Yes, indeed.
Okay, great. Okay, so this was my, you've missed nothing. This was my sort of attempt to explain the foundations of the case law. Now, I think when we look across Article 5, and that's going to be the first comparison that I draw, what we see is that the case law on detention in this immigration context is less liberty protective than in relation to the other grounds in Article 5. So the first point that I want to make is really an argument for a more holistic reading of Article 5. When you look across Article 5, textually, you see that each of these grounds of detention has to be read in a constrained way, because these cases of detention are the only ones that are permitted. Other types of detention are not countenanced under the convention system. And there are types of detention that are marked out both in the text and in the case law for particular scrutiny, what I would call here coercive and preventive detention. And then what I think you can see in the case law is that where the court is attuned to the existence of coercive or preventive detention in the other grounds in Article 5, it's extremely careful to constrain states' detention prerogatives. And in an article that I wrote about this several years ago, I drew on examples of case law under Article 5.1b, for example. Since then, there's been an important Grand Chamber ruling in SV and A as well. So the argument I've tried to make in this article is that particular kinds of detention, coercive detention and preventive detention, need to be constrained if we want to protect the right to liberty appropriately, and that a lot of immigration detention actually is coercive and preventive when you look into it in the individual case. And so really in this article, I'm urging quite a significant rethinking of the approach to grounds of detention across Article 5. So that's my argument. I'm interested in discussing further whether you think it's plausible. The other comparison that's made by many scholars, Galina Cornelissa, Violetta Morena Lax, and myself, is about the absence of a necessity test. I think it's kind of latent in some of the court's case law, but not in all. And in contrast, we find it explicitly in the approach of the Human Rights Committee that there has to be a demonstration of the necessity of detention in the individual case, that we can't just set up categorical assumptions about the detainability of certain categories of migrants, or in particular, of people facing deportation. I think in effect we see this in the case law on children, because there's much more of an emphasis, and it comes through in some other cases too, on the need to assess alternatives to detention. And if that legal requirement is emphasized, then it's in effect a necessity requirement. I'm not going to discuss that case law on children, but recently Judge Turkovic wrote a wonderful chapter in a book co-edited by other members of the court with my colleague Bashak Challa that I recommend to you. The third comparison we find often made in the scholarship, and Mary Benedictine-Boer has really pioneered this comparison, is with the approach of the Inter-American Commission and Court. And in a way, they've established a different starting point, arguably on migrant case law in general, but particularly on the question of how to vindicate a presumption of liberty in relation to migration control, and arguably leading to a set of principles that are more liberty protective. And the final suggestion that I would like to make, and it picks up on a point that I made previously about Saadi, is, how do we integrate principles, or should the court integrate principles from the Refugee Convention? I think the court's approach to other pertinent human rights treaties is crucially important, and I think especially if one thinks of the integration of the best interest principle from the Convention on the Rights of the Child, you can see that this is a very important aspect of the interpretation of any human rights treaty. And in a recent article or book chapter with my colleague, Dr. Julia Joffe, we've made an argument about non-penalization, not only as it derives explicitly from Article 31 of the Refugee Convention, but more generally arguing that it's a sort of a principle of international law that could be read into other, and should in fact be read into other human rights guarantees. And I think that goes to a point that Tristino made in the introduction. When we look at the structure of the convention and human rights, indeed liberalism generally, we have an established framework to constrain punitive power of the state, the criminal power of the state, a right to fair trial, limits on the kinds of punishments that can be meted out, and so on. And I think then we need to take this notion of non-penalization seriously in the migration context, and have principles to help us decide what types of detention are actually penal detention and shouldn't be permitted, should only be permitted in the criminal context. So I think it's fair to say that my scholarship and most of the scholarship to date, or at least my preoccupation, has been on the question of grounds and standard of review and how to vindicate the right to liberty, and some concerns about whether the case law is sufficiently liberty protective. So in that sense, I was quite surprised that the current hot issue, if you like, is whether detention exists. And the reason I think I found that turn surprising is because I think the court established a very good precedent on this quite early in its case law. So in Amour versus France, the court, as most of you know, was faced with the question about transit zone detention or confinement in transit zones, and whether the notional ability to leave the transit zone, in this case to another country, meant that individuals who were confined at airports were not in fact detained. And I think what the court said in Amour was correct. And in fact, that's why I think this issue hasn't been that much tested before. Now, of course, the question of what's the line between detention and a restriction on mobility is going to be a question of degree. But then on the other hand, I think it's important that there should be a bright line, because all sorts of other consequences flow once it's detention, including, duties to allow human rights actors to inspect places of detention. So I think the court got it right in Amour. There's always a notional right to leave because you have a human right to leave any country. And then also you have to assess not just whether that right to leave is practically possible, but actually on quite a high standard. It's whether if the person leaves, they will suffer a detriment. So in Amour, the court talks about whether by leaving you will not be able to avail of protection comparable to the protection you expect to find in the country where you are seeking asylum. So I think the court got it right in Amour. The reason this has become, of course, a hot issue is largely because of Hungary's strategic contestation of this question. So when Hungary was building its transit zones, it was in tandem making an argument that this transit zone was not a place of detention. It was refusing access to inspectors from the UN Working Group on Arbitrary Detention, for example, and maintains the legal argument today that these are not places of detention because people are free to leave, in particular to Serbia across the border. The court in ZA, as you know, essentially reasserts Amour, but I'm not sure it's quite in the same terms. I'm happy to discuss that, whether this highlighted paragraph on ZA is actually a little bit less protective than Amour. But the real surprise was, of course, the Grand Chamber ruling in Ilyas and Ahmed, overruling a unanimous chamber judgment, which had reasserted the point in Amour that transit zones are places of detention if individuals are confined at them. And this notional ability to leave doesn't render the confinement voluntary. which is essentially the argument that would have to be made, because there are legal detriments that would flow from going back, in this case, to Serbia. The language of the Grand Chamber, replete with the language of crisis and also wanting to be practical and realistic, having regard to present-day conditions and challenges. So there's a question not only how to reconcile the Grand Chamber ruling with Amur, but also an internal contradiction with its finding that there was an Article 3 violation, a non-refoulement violation on the facts in the return to Serbia. So I share a lot of the concerns in the scholarship. Vladislava Stoyanova has now written quite a few pieces on the ruling. But of course, that isn't the end of the story. The story continues, and we now have a friction with the Court of Justice in the European Union, which in a ruling in May 2020 asserted that because entering Serbia would lead to incurring penalties, it couldn't be argued that confining people at this transit zone was not detention. And furthermore, they focus more on the objective features of the confinement at this transit zone, its closed perimeter, its high fences, its barbed wire, and so on. So this has set up a friction. It's not the first one in the history of European law. In fact, I wrote a book about the many frictions between the ECHR and the Court of Justice in the European Union. And I suppose the question is whether this is a constructive one. In or in Hungary, the court did seem to step back and say on the particular facts, a particular family that was confined in the transit zone were not there voluntarily. So in their particular case, Article 5 was triggered. The difficulty for me is that seemed like a very fact-specific finding. Again, I do think it's important to have a bright line approach to the line between detention and mere restrictions on liberty. The Court of Justice, again, reasserted its previous finding in its infringement action against Hungary. And of course, these infringement actions are at the heart of the whole contestation about rule of law backsliding in Europe. And really, there's a lot of attention to these infringement actions, and there need to be strategic in order to vindicate the rule of law in Europe. The backdrop, of course, as I said, in some ways is this kind of systematic legal argument being made by the Hungarian state, but also in the background, systematic dehumanization. The court, the last time I checked, had issued 18 interim measures about the food deprivation in these transit zones. And this was reported by ECRA and the Hungarian Helsinki Committee. There may indeed have been more since then. So where do we conclude with this? I hope my presentation has been interesting and provocative, and in a way I'm drawing on a lot of other arguments that I've made. My suggestion is that it's really important to have this bright line definition of detention, not so much a very individualized assessment, is this particular person detained, but because in many situations the individual can leave a place of detention but incur penalties. But really the question is, are they being confined in a place of detention? Because all sorts of positive duties are then incurred once we understand a particular system of confinement as being detention. And more generally, the plea is to sort of think migrants as humans and vindicate the presumption of liberty, particularly constraining, coercive, preventive and punitive detention, at least aspiring to do so in the same manner as detention in the non-immigration context. And think about borders not as lines on a map where people should be confined, but as legal processes that are ongoing. Many people have immigration statuses that are undefined or precarious that shift over time. And we need to think, do we really want these humans to be subject to a threat of detention inherently, or do we want to build in an understanding of migration processes to human rights protection? Thank you very much for your attention.
Thank you very much for not exceeding the time too much. And now I have Judge Martin Mitz, a judge in the name of Latvia, who, before he joined the court in 2015, was the whole his life actually dealing with human rights. And he came to us as a professor from the Riga Graduate School of Law. But at the same time, he was serving as a member of the Constitutional Rights Committee of the President of the Republic of Latvia. He was also a member representing Latvia in the European Union Agency for Fundamental Rights, and he was doing many other functions. So please, and what is very important, he was sitting in both of the cases that were mentioned in your presentation. And so I think that he really could give us a good look into what court was doing. So Martin, please, the floor is yours.
Thank you, President Turkovic. Thank you also, Ms. Costello, for excellent introduction, to which I hope I will be building up. And also continuing with academic traditions, I speak now from Riga Graduate School of Law. So greetings from Riga. In view of the time frame that I have, I will focus my presentation on applicability of Article 5 in transit zone on the land border, as set out in the recent Grand Chamber judgment of Ilias and Ahmed. But I will be also drawing on the general principles laid down in the other Grand Chamber judgment, ZA and others versus Russia, which concerned transit zone at the airport. As we all know, there is a quite solid case law developed by European Court of Human Rights relating to airport transit zones, starting with already mentioned Amur in 1996 and now ending with ZA and others versus Russia. But in Ilias and Ahmed, for the first time, the court was required to assess applicability of Article 5 to the transit zone on the land border. Both cases, and I think it's worth noting, ZA and others and Ilias and Ahmed were deliberated by the Grand Chamber together in the same composition. Now, ZA and others versus Russia. The applicants there were 4 individuals holding passports of Iraq, Palestine, Somalia, and Syria, who arrived in Moscow airport independently from each other, applied for asylum, and spent between 5 months to 1 year and 9 months in the airport transit zone. Well, I think it is worth recalling some general principles which are equally relevant for both cases. So, starting with the key purpose of Article 5, to prevent arbitrary or unjustified deprivations of liberty. Next, in order to determine whether someone has been deprived of his liberty within the meaning of Article 5, the starting point must be his or her specific situation in reality. And account must be taken of a whole range of factors. So it's not one or another which decides the whole thing, whether Article 5 is applicable or not. The difference, as we all know, between deprivation of liberty under Article 5 and restriction of liberty of movement under Article 2 of Protocol number 4 is one of degree or intensity and not one of nature or substance. And the 4 factors specifically taken into consideration by the court in relation to the confinement in airport transit zones are as follows. So first, the applicant's individual situation and their choices, the applicable legal regime and its purpose, the relevant duration, especially in the light of the purpose and the procedural protection enjoyed by the applicants, and the nature and degree of the actual restrictions imposed or experienced by the applicants. So, having assessed these 4 factors relating to the airport transit zones, the Grand Chamber found Article 5.1 to be applicable mainly because of the following elements. And with respect to ZA, I will just summarize. The law did not provide for the maximum duration of the stay in the transit zone. The character of the applicant's stay there was irregular. The duration of the stay was excessive, and the delays in the examination of the asylum claims were not justified. The degree of control in the airport transit zone was similar to that in light regime detention facilities, and there was no practical possibility of leaving the zone without a direct threat for the life or health of the applicants, implying that they would be put on a plane and which would set off for the country of origin. The Grand Chamber also found a violation of Article 5.1f on the merits, in particular because there was no legal basis for the deprivation of liberty in the transit zone. Now, Ilyas and Ahmed versus Hungary. The applicants there were two Bangladeshi nationals who had arrived through crossing Turkey, Greece, North Macedonia, Serbia, and submitted asylum requests in Hungary on its land border zone. They spent in that zone 23 days until their asylum requests were rejected, and then they crossed back to Serbia. So the Grand Chamber applied the same four factors relating to the airport transit zones. The assessment of these factors was as follows, and I will try to do it in a nutshell. So individual situation and choices. The applicants entered transit zone on their own initiative, no prior link or obligation towards Hungary. The legal regime. The purpose was to create a waiting area while the authorities decided on the asylum applications. The applicants remained to wait for the outcome of those proceedings. Duration. 23 days during which asylum requests were processed at administrative and judicial level. The duration itself and diligence of authorities, although not decisive, nevertheless may quite affect applicability of Article 5. So the Grand Chamber in this case found that no inaction was imputable to the authorities. The time limit of 4 weeks stipulated by the law, beyond which the persons had to be left into the country, was noted by the Grand Chamber as an important procedural safeguard. Next, the last one, actual restrictions. The applicants could not enter Hungary. Their movement was restricted to a very significant degree, similar to that in light regime detention facilities, so the same as in ZA versus Russia. But the conditions themselves did not reach Article 3 level. Now, the important question, whether the applicants could leave the zone back to Serbia. And here, as a matter of principle, the Grand Chamber found that the practical possibility to leave the land transit zone by foot is, let's say, more realistic compared to leaving the airport by plane, which involves several factors beyond the will of the person. Although de jure there was no right to enter Serbia, de facto many other persons at the relevant time did so, and the applicants themselves as well. They crossed back to Serbia. In Amur, and here we come to the point that Professor Costello pointed out, the court had held in Amur that the possibility to leave becomes theoretical if no other country offering protection comparable to the one in which asylum is sought is prepared to admit asylum seekers. The Grand Chamber gave narrow interpretation to the statement in Amur, pointing out that it must be read in the context of that case. Again, meaning that there existed essentially only possibility of boarding a plane which would depart for Syria, where there existed a direct threat to life and health of the applicants. In the present case, leaving for Serbia was not associated with direct threat to life and health. Importantly, the fears of chain expulsion, which are subject matter of Article 3, alone cannot bring Article 5 into application. And here is the link with the second point made by Professor Costello. So the Grand Chamber explicitly makes an argument that the lack of compliance with procedural duties under Article 3 cannot trigger applicability of Article 5, at least on its own. Finally, the potential discontinuation of the asylum proceedings should the applicants decided to move out of the transit zone, although relevant in terms of Article 3, is a separate legal question and does not affect their physical liberty to walk into Serbian territory. In view of all these elements, the Grand Chamber found that the restriction of liberty did not amount to deprivation of liberty under Article 5 and declared this complaint inadmissible. Well, there are 2 points I would like to make as a conclusion. First, the main differences from ZA and others case is that in Ilyas and Ahmed, duration of stay in the transit zone was significantly shorter and strictly linked to the diligent processing of asylum applications. The law set the limit for stay in the transit zone. The practical possibility to leave the land transit zone was easier than that in an airport. There was no direct threat to life and health when leaving the transit zone by crossing to Serbia. And second observation, the fact that Article 5 is not applicable in the circumstances at hand does not mean that the applicants are devoid of the protection under the Convention. So in Ilyas and Ahmed, violation of Article 3 was found, and this judgment establishes a procedural obligation under Article 3 for a state when it removes an asylum seeker to a third country without examining the asylum request on the merits. So this is specificity of this case. Yeah? We have an automatic removal of persons to another country without examining the asylum request on the merits. So this puts an obligation to examine thoroughly on the authorities, in this case, Hungarian authorities, whether there is a real risk of the asylum seeker being denied in that third country access to an adequate asylum procedure, providing protection against refoulement. If there exists such a risk of being denied an adequate asylum procedure, Article 3 obliges the state not to remove the asylum seeker to that third country. It must be also noted that Judge Bianco attached his dissenting opinion, which was joined by Judge Vucinic, disagreeing with the Grand Chamber's assessment regarding applicability of Article 5 under all four factors. Now, I must mention a few further developments, which already was also mentioned. The Court of Justice judgment in the two joint cases where the Court of Justice concluded that stay of the applicants in the same land transit zone as in Ilyas and Ahmed amounted to detention in terms of EU law, so directives 2008/115 and 2013/33. Well, we have to note that there are factual differences between Ilyas and Ahmed and the case decided by the Court of Justice. In that case, the applicants waited for more than 3 months in the transit zone until their asylum applications were reviewed and rejected by asylum authority and the courts. The time limit fixing the maximum stay in the transit zone was not applicable. There was no possibility of returning to Serbia since Serbia expressly refused to admit the applicants. So the applicants were stuck in the transit zone for lengthy periods of time. On this point, the Court of Justice specifically ruled, and I would like to quote from paragraph 229, any entry by the applicants into Serbia would be considered illegal by that third country, and that consequently the applicants would be exposed to penalties there accordingly, and in particular for that reason, the applicants cannot be considered to have an effective possibility of leaving the Roske transit zone. And now to compare and contrast, the Grand Chamber in Ilyas and Ahmed noted in paragraph 40, the applicants crossed the border as directed by the UNHCR and not through the forest. Serbian police officers were present when they crossed and only told them to wait for the UNHCR staff coming to need them. The applicants were met by UNHCR staff who helped them. So overall, my conclusion is that factual differences between the two cases are significant, and there can be no conclusion made that both judgments were contradictory on a similar legal issue. There is another case which already was mentioned, RR and others versus Hungary, decided by Chamber on 2nd March this year, which is not final yet. The Chamber found that the stay of the applicant family, again in the same land transit zone, amounted to deprivation of liberty under Article 5. And the Chamber obviously distinguished this case from Ilyas and Ahmed in that the applicants spent in the transit zone almost 4 months. Their situation was affected by the lack of diligence on the part of the authorities in dealing with their asylum requests. Again, the time limit of 4 weeks for the stay in the transit zone did not apply. The law did not set any time limit. other time limits for processing of asylum requests, 60 days, were not kept. A month and a half were spent in isolation section where conditions were more restrictive. So in sum, the Chamber found that the stay in the transit zone in these circumstances amounted to de facto deprivation of liberty and also found the violation of Articles 5, 1 and 4 on the merits. I would like also mention that there are two cases which have been communicated, Azizi versus Hungary and FS and AS versus Hungary, which also concern the stay, this time of unaccompanied minors in the same land transit zone for 2 and 6 months respectively. Now, conclusions. Both Grand Chamber judgments stand on the well-established principled basis under Article 5 of prevention of arbitrariness and the assessment of the specific situation in reality. When assessing degree or intensity of restrictions in the land transit zone, the Grand Chamber followed the same four criteria developed in respect of airport transit zones. However, the Grand Chamber made a distinction in that the possibility to leave the land transit zone by foot is more realistic compared to leaving the airport by plane. The fact that entering Serbia de jure was illegal did not serve for the Grand Chamber as an argument contributing towards applicability of Article 5, as it was for the Court of Justice of European Union. However, in Ilyas and Ahmed, as opposed to the case before the Court of Justice, the applicants de facto had practical possibility to leave for Serbia, and they used this possibility. Apart from factual differences in terms of applicability of Article 5, the Grand Chamber and Court of Justice seems to be attaching different weight to the fact that leaving a transit zone would discontinue asylum procedure. The Grand Chamber expressly pointed out that this is a relevant consideration under Article 3, but not under Article 5, thus separating the subject matter. The cases that follow after Ilyas and Ahmed both before the Court of Justice and before the Strasbourg Court showed that since the Grand Chamber delivered its ruling, the legal and factual situation on the land transit zone between Hungary and Serbia has changed, and now it has even changed more. So thank you very much for your attention.
Thank you, Martins. Thank you very much. And now we will have a comment on the both speakers by Maria Giulia Giuffre. Maria Giulia Giuffre is a reader in law at the Edge Hill University in the UK and a research affiliate to the Refugee Law Initiative at the University of London. Over the last years, among other positions, she has been a research fellow at the Refugee Studies Centre of the University of Oxford. She is involved in several research projects, including one concerning migration in transit zones. She published a monograph on the readmission of asylum seekers under international law. So please, it will be really interesting to hear your comments and your take on this issue.
Thank you. Thank you very much to the organizers for this invitation and for giving me the opportunity to comment on the presentations by Professor Costello and Judge Mitz that I both found very, very insightful. As to the structure of my brief talk, I will share my thoughts on the topics of the webinar and on your presentations. And throughout all my comments, I will pose some questions to both of you. So to follow up from your analysis, I like to start shedding light on the language of crisis used to describe the current trend of European migration. And what I observe is that the court's decisions in the last decade since the Arab Spring, despite crisis discourses, have been more migrant protective than its initial judgments on detention of newcomers, if you think, for example, to Saudi versus UK. And crisis discourses have seemingly had more influence when assessing instead the conditions of migrants' detention facilities, excluding violations of Article 3, such as in Klaifia or JR versus Greece, Ilyas and Ahmed versus Hungary. And nevertheless, something has significantly changed over the last couple of years. This is a consideration that has emerged from your presentations, in particular from Professor Costello's. Probably we cannot speak of a new well-established approach of the court heavily leaning towards recognizing state sovereignty over migrants' liberty interests. However, we cannot but nothing that in a number of recent cases, the court has prioritized states' prerogatives to both control borders and prevent access to asylum, whether this is requested at geographical frontier of European countries, such as in ND and T versus Spain, or through embassies, such as in MN and others versus Belgium. And you have often cited Ilias and Ahmed versus Hungary in your presentations. Here, by stating, as Judge Mitz underlines, that its approach should be practical and realistic, having regards to the present-day conditions and challenges, the Grand Chamber departs from its previous jurisprudence concerning migrants and asylum seekers to a certain extent by adding a reference to the right of states to prevent or circumventing restriction on immigration. These arguments, reiterated also in Zaye and others versus Russia, might fail to acknowledge that the persons attempting to irregularly cross the border, the European border, are asylum seekers claiming protection in a condition of necessity, and that, as Professor Costello stressed, should not be penalized for their irregular entry, as this would be at variance with Article 31 of the Refugee Convention. So no doubt that detention for immigration-related purposes is permissible in certain circumstances. However, what I notice as an external observer is this unresolved tension, this friction, using your words, between, on the one hand, the effort to guarantee human rights protection at the airports, at the land and sea borders, and on the other hand, the need to even more accommodate state sovereignty and their demands for enhanced security and tight border controls. Why is it so? Judge Mitz and Professor Costello, why such an apparent shift in the approach of the court to migrants and asylum seekers? This is an evaluation that I'd like to leave to you to discuss. Moving then more into the jurisprudence of the court on detention and transit zones, I wish to give some inputs to stimulate your debates and thus shift focus on a practice that has so far received limited attention and it's coming to my mind. It's the practice of confinement of migrants aboard the rescuing vessels for several weeks without allowing disembarkation and access to asylum procedures. Basically, rescuing vessels are being increasingly used as a sort of unconventional transit area for migrants waiting for their disembarkation and admission on dry land. In its 3 interim measures to Italy and Malta, the court has only requested the states to provide assistance to the most vulnerable, but has not ordered disembarkation. However, nothing prevents these practices from being brought to the attention of the court to seek their review, also in light of Article 5 of the Convention. Whilst the conditions on board patently amount to degrading treatment, the question that I think should be posed is also whether the practice of closed borders and long standoff at sea would result in a de facto deprivation of liberty in breach of Article 5 of the Convention. And the case law of the court on transit zones that you have thoroughly examined can be also of some assistance. For example, in Ilias, the court accepts that confinement in transit zones is not detention, as it is an open zone, having the asylum seekers the possibility to leave it and go back to Serbia, without ever considering whether it could be safe or not to return there. In a number of other cases, for example, in 3 decisions versus Greece, JR, OSA, CAC, the court has accepted that containment on the islands in semi-open facilities is not unlawful detention under Article 5, paragraph 1, and does not infringe Article 3. However, I'm wondering whether confining migrants on rescuing boats at sea for several days or weeks could be justified considering vessels as open facilities. migrants would be in a condition of de facto deprivation of liberty on the basis of their status rather than a detention order, and with no practical and real possibility, citing Amour and Zayeh versus Russia, no possibility to safely leave the ship and lawfully enter a European country to seek protection. Basically, their only option would be jumping overboard. So I'd like to know what both of you think of this possible scenario of prolonged confinement aboard rescuing vessels. And in a perspective of cross-fertilization with other human rights bodies, as cited by Professor Costello, my next questions for both of you is, what are the risks of a departure from the necessity test in case of detention of migrants and asylum seekers under Article 5, paragraph 1F? And additionally, whether you think that ensuring scrutiny of states' compliance with the requirements of necessity and proportionality might be the new big challenge, especially after the decisions of the Court of Justice of the European Union, which configures as detention the confinement of migrants in Hungarian transit zones. Let's say that on my side, I also believe that the court has its own strong antibodies to reach different conclusions than that one in Ilias in future cases of migrants cross-bordering and de facto deprivation of liberty, as the RR versus Hungary case testifies. At the same time, it is difficult to see how the protective role of the court as the body giving voice to the voiceless can be reconciled with language used, for example, in ND&T versus Spain, referring to African migrants as deliberately taking advantages of their large numbers and use of force to create a clearly disruptive situation which endangers public safety. So I wonder, Judge Mitz, what should be the role of the court as the highest human rights body in Europe in a time in which far-right populist movements proliferate, favoring a persistent criminalization of migration? Indeed, vulnerable migrants confined in transit zones, whether at the land border or on board stranded vessels, are caught, as Barker observes, in a paradigm shift. They are caught in this historical movement away from humanism and human rights norms and toward resurgent nationalism and its darker undercurrents. And it is on these undercurrents Judge Mitz and Professor Costello, and on the role that the court should play to contrast such xenophobic trends baked by the violence of the states, that I like to hear your thoughts. To conclude, despite the current trends, nothing prevents the court from returning to or strengthening its more migrant protective approach. However, this is an open question, and it therefore remains to be seen whether judges in Strasbourg will decide to respond to detention of asylum seekers in future cases in a manner that challenges what may become a perpetual rather than an exceptional emphasis on a migration crisis. Thank you.
Thank you very much. You have already opened the floor for our Q&A session, posing the very important questions to both of our speakers. So I will now open the floor for questions, and first I will ask our both Catherine and Martins to tackle the questions that you have posed, and in the meantime we will see the questions that will be posed by the audience, and we have Paolo Loba at the court, and since I cannot see the questions, then he will read the questions to you, and then you can respond. So please, Catherine, would you like to start, and then we will give the possibility to Martins after that?
Perhaps I could just intervene and explain that if the audience watching would like to ask questions through the chat, this is available Q&A on the right-hand side of the blue jeans. Thank you.
Thank you so much, and thank you, Maria Julia. That was Very thoughtful and thought-provoking comments. On the question of crisis, I think one thing that strikes me is to compare. I know you're discussing COVID-related confinement in the next session, but in that context, the interesting discussion is about using emergency powers and whether that's warranted. And in a way, I see the language of crisis has this danger of circumventing the appropriate legal response if there is a legal crisis, which is to decide whether it's an emergency in a legal sense. And then it would have to be time-bound. I mean, the notion of crisis has no basis in law. And, in international legal scholarship, there's wonderful work by Hilary Charlesworth, for example, on crisis and how problematic the term is. So I guess I understand why it's there, and the court, obviously all courts have to be responsive to their interlocutors and have to think about compliance with their rulings and so on. And it's not just Hungary making arguments of this nature before them. There are very, strong arguments being put forward that are sometimes convincing from government lawyers. But I think invoking an amorphous notion of crisis is so difficult to reconcile with the rule of law that it's really problematic. And I love your counterfactual about the boat, but I'm going to add another layer about confinement on boats. Imagine if they were pirates or drug dealers and they had been intercepted. I think we'd agree they would have been arrested. And Article 5 applies to even short periods of arrest. Of course it does, because you're deprived of your liberty. So with respect to the court and to Judge Mitz, this question of time does not go to the existence of a deprivation of liberty. It goes to its justification. And you can't make the question, is the person detained, depend on duration. It has to be about the quality of the confinement. So if there was a law enforcement operation at sea and pirates were taken on board a vessel, you would say they had been arrested because they've been deprived of their liberty. So it's not even a difficult case. It's just that the exceptionality of how we think about migration is skewing our thinking so much. And that was in a way what I was trying to do with saying, just think about this holistically. There are also other examples of detention where you have a right to leave a place of detention, but you would incur penalties and it's nonetheless still a place of detention. And I think that's why the attention has to be much more on not whether you can leave, but what happens if you leave. And looking at those consequences, and you shouldn't have to demonstrate that it's going to be an Article 3 violation. I think any material or legal detriment, if you leave a place of confinement, which is a carceral space, which is kind of legally regulated in that manner, should be regarded as detention. And then on your question about cross-fertilization and necessity, I think that is really where the discussion should be. I mean, these practices have to be subject to a lot of judicial scrutiny. And deciding that it is detention is just the start of a procedural, a judicial inquiry, and also the question of access to these places of confinement for inspections in order to prevent atrocities taking place is really crucial. So I think we have to look at this question functionally as well. So, I mean, if you look in the UK, what happened post-Sadi, the court gave the UK a green light to maintain the detained fast track. And it took decades of domestic litigation to demonstrate that it was all completely illegal under British law. And, all sorts of other problems with it. And none of these arguments about the efficient functioning of the asylum system were ever borne out in practice. And it was truly arbitrary in the sense that whether you ended up being detained on arrival was just a matter of the lottery of beds available. And if the person that you happened to manifest your need to claim asylum to felt like you were the right kind of person to detain. So, I mean, that is why these are protections against arbitrariness. And so I think it's really crucial to think these points through from sort of first principles, which is why I think you're asking the question about vessels is really useful. But imagine they're not migrants, imagine they're criminals. And the answer is really clear. Of course, they're under arrest. Yeah, thank you.
Thank you very much. Martins?
Yeah, thank you very much for very interesting and challenging thoughts. As to the question of the boat, we see that in Ilyas and Ahmed, which concerns land borders, we have to go into the very great level of detail in order to come to the conclusion about applicability or inapplicability of Article 5. because as I tried to emphasize these very general principles at the very outset, the applicability of Article 5 depends on the whole range of factors, right? And the situation with both is completely different from the one we were dealing with in Ilias and Ahmed. So for that, the whole exercise would be from anew for the court. That's one thing. Second, ND&T and the language used. I happen to sit also in that case. I think that the language used is correct in describing the relevant situation, because again, and it was peculiar situation in that case. Overall, putting into the more global perspective, I understand your intention to see the court as a guarantor of freedoms, but I think that there is a certain line between being guarantor and being proactive protector, which is also a fine line to make, and we have to be mindful of the court's role of the one which applies standards in the convention. But when you're saying that there is a shift in the discourse moving into the crisis discourse, I do believe you. I think that from a side you do see it even better than perhaps judges from inside. But if we even talk only in the context of Article 8 and debate we have, I intentionally, again, referred to this general principle that the starting point must be person's specific situation in reality. This is the age-old principle, right? This is not the one which has been now kind of added by the court. Professor Costello was absolutely right. There is on top, there is something more topping added to that, in the reality. But well, and that probably is slightly different for how the whole convention system operates, and also how the court operates, is that it does take a very deep but individual look at each and every situation, and this might explain some differences with either UN treaty bodies or with some other international courts. I think that in all these cases, even if there is a sort of certain deference to the processes which are taking place, I think in all these cases there are still the convention serves as a guarantee, and the convention obligations are reaffirmed. Even in Claithia concerning Article 3, I think that there is an express pronouncement from the court that actually, even if there is a crisis, the Article 3 guarantees are absolute. But here, I think that we have to reflect about something bigger, and we are living at the moment in the times when even the fundamentals of the values have been started to be challenged. The migration hugely affects the populations in Europe and in the world in general. Professor Costello invoked emergency powers. We see now in a COVID context, it's states are confused. 10 states made derogation under Article 15. Other states didn't. I think that COVID indeed affects our core rights and freedoms as we live. So what I'm saying is that there are processes taking place which really makes the usual, the traditional environment rather unstable. And here the question can be posed actually whether the court, with its individual justice approach, is really the right forum or instrument actually to try to address and correct all these processes which are taking place. You are absolutely right. There is and there must be courts' role into that. But I think that it's a very interesting question. What exactly is its role of the court as a court which applies one particular legal instrument, European Convention of Human Rights? So with that, I will stop. Thank you.
Thank you very much, Martins. I don't see, but I'm asking now whether we have some questions from the audience. We have already exceeded our time, but I think we could continue. Yes, Paolo?
Yes, we have a question to Professor Costello. Please, what will you say is the right terminology to refer to those being detained in transit countries? For instance, in the case of those traveling through Turkey to Europe, are they undocumented migrants, asylum seekers, border crossers, etc.? Thank you.
Did I answer straight away? I mean, I think the labels matter a great deal, but it also matters in what context you're speaking. I mean, I think I would say, people on the move sometimes works as a generic phrase. I mean, I don't know anything about the people you've asked. They could be moving irregularly, they could be moving regularly, and people often use regular to forestall using pejorative language about legal or illegal. Under what law are we talking about? So, I mean, I think maybe people on the move, just human beings. I mean, it's hard to say in general. I mean, it's important to note that refugeehood is declaratory, or refugee status is declaratory. So people are refugees by virtue of having fled with protection needs of the appropriate gravity. And so you can be a refugee without ever having been recognized as a refugee. And so Syrians in Turkey don't benefit from the term refugee under Turkish law. They're under a regime of temporary protection, but most people would regard them as refugees. So I think the question is important, but there isn't a singular answer, and it sort of depends on what those labels mean in different contexts. And if you're using it in a legal sense, or you're just trying to convey people's human predicament in terms of what challenges they're facing.
Thank you, Paolo.
Yes,
Paolo,
we have two more questions. I would just read the first one. Thank you for this great debate. My question is to Professor Costello. Could you please expand on what you mean by the exceptionality of the way we think about migration law in the context of confinement of people on the move? Thank you.
I'm going to give a short answer because on the slide is an article I wrote in 2015, and I'm really happy to share it, but it's based on just comparing across the grounds of detention and showing how when detention in particular is coercive, when it's trying to force people to comply with legal processes, or preventive, like stopping them doing something they may do in the future, but we're not sure about whether that risk will emerge, that not only the Strasbourg Court, but human rights bodies generally, and indeed I would say the rule of law, is very cautious about those forms of detention. But they're intrinsic in a lot of immigration detention. When you say, why is somebody being detained? They'll say, well, so they don't abscond. And then you say, well, we don't know if they're going to abscond. So these types of detention are often either explicitly or implicitly coercive or preventive. And it's not to say it's always unjustified, but they warrant very particular forms of justification, and they shouldn't be normalized. And that's, I think, the argument that I've made. But it's drawing on the court's own principles. I mean, that's really trying to say, like, why treat immigration detention so differently?
Thank you. And the other question, Paolo,
the last question is, would not an approach affirming the existence of the privation of liberty in Ilias going to prompt states to not even admit migrants within their jurisdiction, as in that case the entry is lawful, unlike the case where migrants are detained following an unlawful entry into the state's territory?
I mean, I don't think the material circumstance, it wouldn't have been that different to say it was detention, because it would be just applying SADI, and SADI already gives the state quite broad powers to detain. It would just have to be not arbitrary detention, and that would mean not for too long in the appropriate conditions. So it wouldn't really be a game changer. In a way, Hungary was making this argument, I think, but I mean, this is my impression from the outside and just having watched these cases unfurl as a bit of a provocation. It's still making that argument before, in light of the EU ruling. And, you know, certainly not admitting inspectors from the Working Group on Arbitrary Detention was a provocation. It was doing this very publicly. You can get press releases in English about it. So you know, it made this the legal issue, but really would it have changed that much if it was detention under SADI? I mean, I think it would have been better because, you know, there would have been maybe more constraints and on how long, and the court might have had a more active role in making sure that it wasn't detention for too long, just applying the SADI criteria, but I don't think it would be massively different.
We have a request.
Yeah,
I
would like
to Professor
Costello,
like and then we have a final. Yes, a
Sorry,
final
Paolo. I would like Martins. Sorry, I would like Martins to answer, and then you can pose the last question. Is that okay?
Yeah. Well, you can also turn the question around and say that if this Ilias ruling then might encourage states to, so what are the elements? First of all, to allow people to stay for a relatively short duration, to deal with their asylum requests in a fast and diligent manner, to have a procedural rule on how long they can stay in that transit zone, and if there is a possibility, practical possibility to leave the zone. So, I mean, in such a situation, actually there can be also some positive consequences or drawn from this ruling. Yeah? Thank you.
And the last question, please, to both speakers, as I have understood.
Yes, so we have a request to Professor Costello if we can share with participants the slides that you prepared. And the question is, many thanks for an enlightening discussion. My question is as follows. What would your initial thoughts be about the legality of transfers of asylum seeker processing from one state to another, especially in regards to monitoring responsibilities of detention? To both Professor Costello and Judge Metz.
I don't know, Judge Metz, if you want to go first on that.
I mean, on the question of monitoring, actually, in both these cases, Ilias and also ZA, the court acknowledged that the overall regime, including the monitoring to which the applicants were submitted, were quite stringent. But on its own, it did not made the balance in favor of applicability of Article 5 because of all these other elements. So in this specific context of Article 5, so the conclusion is that there are no strong consequences from this element on its own, as perhaps it might be under Article 3, which is a different story.
Yeah, I don't think I have anything to add on that point, and it opens up a lot of other potential legal issues.
Okay. Thank you very much. So we will wrap up. We exceeded for 14 minutes our session today, but I hope that you have enjoyed immensely. I think it has opened an important question, important questions for the court. And really, the court is always looking very carefully what is happening in Luxembourg and, in which way and how our case law is interacting. And personally, I was sitting in both cases, and when I'm reading them, I do see a little bit of friction, but not such a big friction as it is very often portrayed in academia or by the NGOs. Actually, the court was very, very cautious in writing judgment in Ahmed and Ilyas, and what was really important for the court in that case, it seems to me, as Martins has emphasized, was Article 3. And this is somehow overlooked very often, that this case brought one very important novelty, we would say, and this is this procedural protection under Article 3, and the court somehow didn't want to just transfer this procedural protection under Article 3 and to find a violation under Article 5 on the very same basis. At the same time, the court was very cautious, and for example, if you are looking at paragraph 237, the court was of Ilyas, the court was in a different position than Luxembourg, with much less knowledge of what would happen if the asylum seekers would be sent to Serbia. And so the court said it is probable that the applicants had no legal right to enter Serbia. But the court notes, however, that Serbia was bound at the relevant time by a readmission agreement concluded with the European Union. And then the court said it is not the court's task to interpret that agreement. What EU court later on did and said, you know, there are no legal basis. So that opened then the door for the court that in future cases, the court on this basis can find a violation, but was not able in Ilyas and Ahmed. And the court was very, very careful to emphasize that. So, and then in terms of the necessity and proportionality and the analysis related to arbitrariness under the approach by our court and the approach by the Luxembourg, if we really very carefully read the case law and the way how arbitrariness is interpreted under the our case law and the way how necessity is interpreted under the Luxembourg approach, you actually see that there is a lots of convergence, and for example, they rely on due diligence. We rely on due diligence. They rely on realistic prospect of removal. We rely on realistic prospect of removal. So actually, when we are talking about arbitrariness, we are coming very close to the necessity, and the difference is not so great. So I think that we see that merger, but it's coming from a different, how would I say, in a different way. At the end, we are approaching very, very similar result. So thank you very much, and I hope that the audience was enjoying, and it was really insightful, and great questions by the commentator, and a great presentation by our presenters. And thank you really very much for your time and for being with us and sharing your thoughts with us.
Thank you.
Thank you very much.
Thank you so much.
Thank you. It was very stimulating.
Yeah.
Bye. Have a good day.